Lord?
Yes.
Am I audible, my Lord?
Yes, Mr. Shankar. Yes.
Deeply obliged, my Lord. Yes, my Lord.
Yes.
Please, Your Lordship. Lordship may take notice of the decision of the Supreme Court in the case of page 25, my Lord.
Yes.
Page 22. No, my Lord. This is last decision I want to refer on this. Chuganmal Rajpal, my Lord, page 25.
25.
25.
Yes.
And the observations which I want to bring to Your Lordship is at page 27.
Yes. Please read.
I'll read, my Lord. I'm coming, page 27. The amount of escapement involved amounts to 1 lakh. SP Chalia, Income Tax Officer, Ward Muzaffar. After that, I will read, my Lord. In his report. Lordship got it, my Lord?
Yes.
And the 22 last para, my Lord. In his report.
In his report. Yes.
From there, I'll read just about 10 lines and then leave it to Your Lordship. In his report, the Income Tax Officer does not set out reasons for coming to the conclusion that it's a fit case to issue notice under 148. The material that he has before him for issuing notice on 148 is not mentioned in the report. In his report, he vaguely refers to certain communications received by him from the Commissioner of Income Tax, Bihar and Orissa. He does not mention the facts contained in those communications. All that he says is that from the communication, it appears that those persons, alleged creditors, are name lenders and the transactions are bogus. He has not even come to the prima facie conclusion the transaction to which he referred to are not genuine transactions. He appears to have had only a vague feeling that they may be bogus transaction. Such a conclusion does not fulfill the requirement of section 151(2). What that provision requires is there must give reasons for stating a issue of notice 148. In other words, he must have some prima facie ground before him for taking action under 148. Further, his report mentions, hence proper investigation regarding these loans is necessary. In other words, his conclusion is that there is a case for investigating is the truth of the allegation. This is not the same thing as saying that there are reasons to issue notice under 148. Before issuing notice under 148, the income tax officer must either have reason to believe that by reason of the failure of the party to make return under 139 for any assessment year to the income tax officer, or to disclose truly and full metal facts for his assessment for that year, income chargeable to tax has escaped assessment for that year, or alternatively, notwithstanding there be no omission or failure as mentioned above on the part of the assessee, income tax officer as consequence of information in his possession, reason to believe that income chargeable to tax has escaped assessment of any assessment year. Unless the requirement of clause A or clause B is satisfied, the income tax officer has no jurisdiction to issue notice under 148. Decisions which notice under 148 reasons are very, very important. Now, there are two things, my Lord. In the process of which a notice is challenged is one way of doing it. People challenge the notice, or in the alternative, they go through the normal process, but still keep the notice as a valid challenge. That is what has happened in this case. The alternative was that we could have gone on a writ court and said the reasons are not there. We go through the alternate remedy process and then challenge the same thing. There are a number of decisions. Why I am making this submission, my Lord, is I am expecting my friend to make a statement that the notice under 148 can only be challenged in a writ court and it cannot be gone through the appellate process. For that, I am making a foundation now and I'll reply appropriately because some of the decisions he has placed on record deal with such situations. Now, my Lord, I seek your Lordship indulgence in taking the appeal memo, my Lord. Lordship will notice the assessing officer at page 47. The assessing officer at page 47 has reproduced the memorandum of understanding in the assessment order, page 47 of the appeal memo. Your Lordship, at page 51, you all should get it that this memorandum has been entered on first day of October 2007. Lordship, got it, my lord? What I'm trying to drive home the point here is, my lord, at page 43, the only reference he says is the assessee, Mr. Wilfred D'Souza. Once again, I want to correlate this with the memorandum to say that it is not a very correct recording, to demonstrate to your Lordship that the recording is not in accordance with the memorandum of understanding. Lordship will see the assessee Wilfred D'Souza has received payment of 30 lakhs in financial year 78 as per memorandum of understanding dated 1/10/2007. Now, Lordship, if your Lordship were to come at page 47 in the memorandum of understanding, which he has reproduced in the assessment order, Lordship will get it. At page 50.
Yes.
A sum of rupees 2 lakhs was paid on 1/7/2006. That is not pertaining to this assessment year. And the balance consideration of 2 crore 30 lakhs. Within 1 year. Now, your Lordship, for a moment, if you take my appeal memo at page number.
You have received it in 2008.
This is for 2008. No doubt that the memorandum is dated, your Lordship may say memorandum is dated 1st October 2007. Your Lordship will get at page 51. 1st October 2007 is for assessment year 2008-9. There's no quarrel about that. I want to say that first payment of 2 lakhs was received on 1/7/2006. Now, yes, your Lordship will notice the second para says the balance will be given within a period of 1 year from this date. Now, for a moment, your Lordship will see at page 11 of my appeal memo, page 11.
Yes.
Your Lordship got it, my lord. Page 11, para K. K for kettle. The dates on which the payments have been made, total 232, are mentioned by me. Your Lordship, yes, will see 6/11/2007 is 15 lakhs. 17/1/2008 is 15 lakhs. Both put together are 30 lakhs of rupees. Lordship got it, my lord?
Yes.
Second item, first item is 2 lakhs. Second and third item are 30 lakhs. The remaining thing came in the next year. It did not come during this year at all. Now, this 30 lakhs of rupees came on 6/11 and 17/1.
Yes.
Now, your Lordship may see page 51.
Yes.
51, my lord. In witness whereof, the parties hereto have signed the memorandum of understanding on the first day of October 2007. So, on first day of October 2007, there is nothing in this memorandum to indicate that I have received 30 lakhs. What I am trying to draw your Lordship attention is the fact that He writes, as per MOU, I have received 30 lakhs. There is nothing in this memorandum to say that I have received 30 lakhs on 110, because I have received the monies after 110, that is on 6/11 and 17/1. So the very foundation, the basis of reason to believe, as per the memorandum I have received 30 lakhs, is not borne on records. And consequently, the reasons recorded does not show the live link between the material in his possession
Yes.
and the reasons recorded. Challenge of the notice is different. I am now questioning the reasons recorded. There is a difference between challenge of the notice and challenge of the reasons recorded. So in view of the fact that this memorandum, fortunately for me, has been reproduced by the assessing officer himself as part of the assessment order. So on the date on which and the reasons would have been recorded, my lord, according to me, before the issue of notice, I don't have the exact date because the officer communicated to me on 30/10/2002 at page 43. The notice has been issued on 16/7/2010. So before 16/2010, these reasons have been recorded as given to us by the assessing officer. In view of the same, my lord, my submission is on the day on which he recorded the reasons, based on the information he has put in the reasons, there is nothing discernible to say that the sum of rupees 30 lakhs is there on account of the
Yes.
reasons recorded. In view of the same, my lord, if the reasons itself do not constitute anything germane to the material in his possession, I do not know how we got the figure of 30 lakhs from the MOU. It means he must be having some other information or he has no other information. Because, my lord, by the time, I think we have already filed the return for the assessment year 2009-10, where we have declared this entire income. And then his contention is it is not liable for tax for the assessment year 2009-10, but it is liable for tax for the assessment year 2008-9. That is the controversy on merits, which I'll take your lordship now onto the facts of this case. Thus, as far as the reopening is concerned, my lord, my respectful submission is that the reasons recorded are absolutely has no live link to the material in his possession and what he has relied upon. The reasons recorded talks of 30 lakhs and the memorandum does not even indicate it. And according to me, my lord, this does not constitute reason at all. And consequently, the assessment made based on these reasons are bad in law. I'm not saying that the notice is bad in law. He has a right to issue a notice, but the assessment consequent to that is bad in law. The lordship may note the fine difference. The notice he has issued, but an assessment which does not fall within the parameters of 148 reason to believe, the assessment is bad in law. That fine difference, your lordship may notice, because I expect my friend to place a few judgments. So I thought I will cover that up now itself to save some time for your lordship and reply. Now, my lord, I'll go to the merits of the case. The merits of the case are the appellant purchased a property from one Shrishta family in the year 1996, and the matter went into litigation. In the meanwhile, this person, Rohan Montario, made the sellers of my property. The sellers of my property registered the property in favor of one Guruswamy, and from Guruswamy to one Mangalore Internet Private Limited, and sold off the properties when I had a valid title and I had a valid agreement subsisting, and I also challenged it for specific performance. In the meanwhile, Mr. Montario came and wanted to settle all the disputes. He offered to pay me 2.32 crore because I had already incurred a cost of, the lordship will get the cost incurred by me at page number 58, my lord. ₹84,40,000 I have incurred. Your lordship will get it at page number 58. Your lordship have to ignore the index part, the left hand original part only, because under the computation provision, the AO has written both the index cost and that. I am talking of only 45 lakhs, 21 lakhs, 11 lakhs, 96 lakhs and 50,000 at page 58. The total of the their index cost of acquisition, serial number, financial year 95, 96, 45 lakhs. That column alone, if your lordship will total, it will come to 84 lakh 40,000. Page 58, my lord. So I have paid 84 lakh 40,000 rupees to acquire the property from Shrestha family, which agreement I have placed at page 101. This agreement is dated 10th day of February 1996. Later disputes happened. One of the important aspects of it, my lord, is that lot of tenancies were claimed on the property. I had to evict the tenants, and consequently, all responsibility was mine. So I evicted those tenants and took possession from those tenants, which I have placed that agreement today in my paper compilation at page number, that one has been missed out in filing, my lord. I have placed it in today's paper compilation at page number 158 onwards. Today's, just this one document alone, I'll refer to that other compilation, my lord. Page 158 of the other compilation, because the chronology will become all right. Because this is on 15th November 96. Your lordship will get at page 158 the agreement between the appellant before your lordship and one Francis Harold Lancy Cresta, who was claiming to be in possession of the property. And your lordship may straight away come to page 162. After settling with him, I took possession as per clause 5 of the agreement at page 162. Subsequently, your lordship may come back to this just to point out, your lordship, how I took possession originally. Subsequently, my lord, litigations were there in which the persons who sold the property to be, and consequently there were litigation, agreed to pay me 2 crore. In the meanwhile, there were a lot of litigation, and I was expected to withdraw those cases before I get the money. So, in fact, I would like to place before your lordship, as far as the litigation is concerned, the trial court has held that I was not in possession, which order I placed at page 115 of the appeal memo. The trial court has said I am not in possession. But I had filed an appeal before the High Court and the matter was pending. Ultimately, the matter got resolved, and on resolution of the same, I had to withdraw the cases which I have filed, and they had to give me the money. They gave me the final money as per para 11, page 11, para K. The last money came on 30th of April 2008. 30th April 2008 is for the assessment year 2009-10. It starts from 1st April 2008 to 31st March 2009. The basis for my claiming that was a very important piece of evidence. The lordship will get it at page number 152 of my appeal memo. I'm not on reopening now, my lord. I'm on the merits of the matter. Whether the assessment should have happened this year or that year. Page 152. This is a deed of surrender, which is a very, very important piece of evidence, which completely everybody has overlooked. The officer says it has no relevance. And the most important thing, my lord, is your lordship at page 153. The last but 2 para your lordship may see. at 153. The first party has also delivered all the documents in his possession regarding the scheduled property to the second party, and also as per the instructions, the second party surrendered the possession of the property in favor of Bangalore Internet City Private Limited as per MOU dated 1/10/2007. So I handed over the possession of the property only on 30th day of April 2008. I did not give possession of the property prior to that date. So according to me, the taxability of this transaction comes for assessment year 2009-10. Notwithstanding the fact in civil court, I did not succeed on temporary injunction. My contention was that this document is what I gave possession. In fact, if the other side was of the view that they were in possession, the agreement that they would have taken was not to ask me to give possession. They would have asked me to surrender, confirm that they are in possession. Your Lordship, I notice the fine difference at page 153. The parties have not asked me to confirm that they are in possession. They are asking me to hand over the possession. And now the department cannot rewrite this agreement when this agreement is not found to be anything otherwise normal. And this coincides with the date of last payment of 1 crore, which I received on 30th April 2008. I received on 29th April 2008 75 lakhs and 30th April 1 crore. So the deed of surrender of my property was on 30th April. So my contention was that it is assessable for the assessment year 2009-10 and not for the assessment year 8-9 as per what the officer is doing. Now, what the officer says, my lord, in respect to the merits of the matter, I will take your lordship through the assessment order, CIT order and the tribunal order briefly, not everything, my lord. The assessment order, your lordship, it starts at page 44. And up to 51 was the literally reproduction of the MOU, which I don't want to read once again. Your lordship may say page 53. But four paras. Here it is brought to your attention. Lordship got it, my lord? Here it is brought to your attention that you have never purchased the property as such, but have only entered into an agreement to purchase the same, and therefore the property never came to your possession, and therefore the question of handing over possession of the immovable property does not arise. Also, you have to clearly stated in the MOU that you are hereby assure and declare with the second party that you will not make any claim whatsoever nature in the scheduled property or again the aforesaid previous owners with whom you have entered into an agreement for sale, and also against the present owners, namely Bangalore Internet Private Limited. Their whole observation is, since you already undertaken to give you all your claims in the MOU itself, the deed of surrender of possession of immovable property dated does not have any relevance and only a document of convenience. This is absolutely not a correct finding, my lord, because according to me, I have received, it is not that I received the money 1 year back and I am giving possession after that. The lordship will notice, human probabilities are fully aware. I received the last payment of 1 crore on 30th April. On 30th April, I gave it. And 29th, I got 75 lakhs. It falls within the parameters of human probability. It is not that I received the money 1 year earlier, and I am giving a surrender possession 1 year later without anything to be done from my side. Normal transaction, when you receive money, you hand over possession. So that is precisely what normally this is absolutely nothing. And there's nobody. He's not doubting the transaction. He's only saying it is convenience. At that point of time, nothing was even contemplated like this, that they are going to reopen the assessment or anything like that. And I have already filed my return independently for the next year. Now, your lordship. Their contention is that in the MOU itself, I have given up all my rights, and the question of the possession and other things are not relevant. And that is how they have evaluated the two provisions of the Act. I will come to that provision later. Now, my lord, the CIT effectively repeats the view of the AO. at page 76 may be noted, my lord. Very important observation of the CIT, which is contrary to record. Last 5 lines at page 76 may be seen. Page 76, my lord, 76.
Yes, yes.
Got it, my
Yes.
lord?
Yes.
I'm waiting for. Yeah, my lord. Last 5 lines. The argument of the appellant. 5 lines. The argument of the appellant that possession was taken over by him when he got the tenants withdraw the suit is also not relevant. Now, in my other paper compilation, I showed your lordship that I got the possession from the tenants whom I vacated. He says the suit of the tenant is against the owner, and if the tenants have withdrawn the suit, I have entered into an agreement with Shishta family. I have vacated the tenants. I have got possession of the property, and I have handed over possession to them after settling of the dispute or undisputed facts. Only thing is the interpretation placed by the assessing officer. He is saying it is a matter of convenience. No doubt I have lost in the trial court that saying that I am not in possession. At the cost of repetition against me, I am keeping your lordship on the factual aspect. And page 77, we note, my lord, para 5.4, the commissioner says that I'm para 5.4, as could seem from the above discussion and a plain reading of the MOU, along with the assessment order, the MOU being made part of the assessment order, it is very clear that there is no scope of two interpretation. It is only the appellant who is trying to take the capital gains for 910 to take advantage of set off of business loss. Under circumstances, I do not find any merit in the argument of the appellant. Accordingly, the appeal is dismissed. The commissioner completely ignored the two important aspects. They do not deal extensively with the deed of surrender, which I told your lordship at 158. And they don't forget that the human probability, the payment was received only on 29th and 30th of April. When I received the money only on 29th and 30th of April, it would be very difficult to comprehend that possession was given up the earlier period. Now, my lord, how the tribunal deals with this issue. Page 28. Page 28, my lord, tribunal order. Tribunal order, my lord. Para 11. My submissions, I'll read this 3-page order, my lord, so it will help to understand the factual aspect of on the merits of the matter. Coming to the merits, the learned AR submitted that MOU entered by the SC with Rowan, Ontario was no doubt in relevant previous year. There's no quarrel. On 1/10/2007 is relevant previous year is 8/9. There's no quarrel at all. According to him, a reading of the said MOU, a copy has been placed at page 97 to 109, which they have also reproduced in the order which I took your lordship to, show that a sum of 2 lakhs was paid by the SC on 1/7/2006, which fell in the previous year 6/7. My argument, the notice, relevant to the assessment year 7/8. Hence, according to him, even if the MOU was considered as something which transferred any rights, the capital gains, if any, would be relatable to 7/8. Only a sum of 30 lakhs was received by the SC during the previous year relevant to the impugned assessment year. The balance of 2 crores was received by the SC only in the previous year relevant to the assessment year 9/10. SC has returned capital gains out of the transaction assessment year 9/10. There's no quarrel, admitted position. The transaction, whether considered in assessment year 7/8, 8/9, or 9/10, were revenue neutral. At the end of the day, it is a question of same amount of tax and carry forward of loss. Further, according to him, the original agreement for sale entered by the SC with Shishta family was to be handed over to Rowan, Ontario only at the title of settlement of full consideration, which happened in the succeeding assessment year. Possession was also handed over only in the subsequent year, which I had taken your lordship to the deed of surrender. Thus, it was only an executed contract, and the contract would fructify only when both the parties discharge their respective obligation. Relying on the paper book number, which is part of the original agreement dated so-and-so, entered as SSC with Shishta family, AR submitted the possession was handed over to the SC by Shishta family in 1986. I'll skip that, my lord. Then the DR submission at page 12 and the tribunal finding at page 13. Para 13 at page 30. We have perused the orders and heard the rival contentions. There is no dispute that C has entered an agreement with Shishta family on 10/12/96 for purchasing the subject property from them. There is also no dispute out of the 1 crore agreed. C has paid 69 lakhs by 99 and the further 84 lakhs your lordship pointed out the officer has accepted. SSC itself has filed a suit for specific performance as per the said agreement and also an application for getting an injunction prohibiting them from selling the property to any other person. Thus, by virtue of the agreement he had with Shishta family, the SC did receive a valuable of right in the subject property. The Honorable Apex Court in Sanjeev Lal versus Motilal held as under at para 20 and 21 of the judgment. I'll skip the judgment for the time being, my lord, as I intend to treat the full judgment in my compilation. I'll skip it for the time being. Thus, there cannot be any dispute that the SC had valuable right in the subject property by virtue of this agreement with Shishta family. By the agreement dated 1/10/2007, that is the MOU, with Ron Ontario, SSC has relinquished the above right for claiming specific performance. One plain plank of argument to the SC is that major part of the consideration as per agreement was still to be paid, and during the relevant previous year, only 30 lakhs was paid. Another line of argument taken by the SC that possession was not handed over, and it had handed over only when substantial portion of the consideration was received in the subsequent year. That is totally wrong, my lord. Not when substantial portion was received, when our entire consideration was received. The lordship will notice 30th April 2008 is not when I received substantial, when I received the entire consideration. So this observation of the tribunal in the order is patently not correct. For resolving the issue, it necessary to look at the pertinent clause of the agreement entered by the SC with Rowan Ontario. Relevant paragraphs of the agreement are reproduced under. In pursuance of the aforesaid undertaking, the second party has paid to the first party sum of 2 lakhs. I'll skip the first one. Second clause is regarding 2 crore 30. There's no dispute. Third, I told your lordship there is a dispute in which the civil judge did not give me injunction. I mean, he did not give me interim orders. Para 5, 6 are all normal clauses. Para 7, that I agreed to give the document only at the time of settlement of the entire consideration. I still have the original document and agreement with me. At that point of time, you cannot say I have extinguished all my rights. Now, then the tribunal at para 15, only small 2 more pages, my lord. Pursuant to the above agreement, SC has admittedly filed withdrawal memo withdrawing OS number filed by him, copy as which has been placed at page number 102 to 103. This was filed by him on 13/11/2007 and approved the court, and these events also fell within the currency of the relevant previous year. The SC has complied the condition and discharged the obligation mentioned in the agreement. And the moment the SC complied with the obligation set out in the agreement, it becomes an executed contract. What was left was only receiving the balance amount of total consideration of 2.3 crores. In other words, there arose a debtor-creditor relationship between the SSC and Rowan Ontario the moment SC withdrew the suit for specific performance and made an application for settlement in the competent court. Additionally, the Apex Court in Excel Industries with learned AR only supports the case of the revenue. Honorable Apex Court held that income would accrue and become due only when there was a corresponding liability on the other party to pay the amount. Here, the moment the SC withdrew his claim over the subject property, Rowan Ontario became legally bound to pay the balance consideration. Just because payment were scheduled for a later year would not, in our opinion, change the position. Coming to the handing over of the earlier agreement for sale, which has been relied upon by the SSC, the relevant clause in the agreement with Rowan Ontario clearly mentioned the earlier agreement with Shishta family stood cancelled. In any case, it was not a title deed. SSC has been brought into capital gains not by virtue of clause 5. Now I am going to take your lordship the legal grounds which they have raised. Very important observations, my lord. Page 36. SSC has been brought to capital gains tax not by virtue of clause 5 of 247, but by virtue of clause 2 of section 247. In other words, capital gains arose on relinquishment of a right. Coming to the last aspect of possession, it is clear from paragraph 36 of the order of the civil judge in the interlocutory application for temporary injunction against Shishta family, which has been reproduced by the AO, the assessment order, the SC was not having possession. The same is reproduced. I'm not on quarrel. Definitely that interim order. That is what I challenged that before the High Court, and the matter was pending. I was asked even vacate that. So there is no quarrel about it. Coming to the last line of agreement, para 17, my lord. Whether capital gains which are offered in the current year or subsequent is revenue neutral, in our opinion, is not acceptable. Learned CITA clearly mentioned his order. The assessment year 2009-10 capital gains return with SC was adjusted against business loss, and this position has not been disputed. My lord, if now these are all the findings of the tribunal, and reopening I read to a para 17. Now your lordship will notice the tribunal has completely gone wrong on 3 issues by not referring to the deed of surrender of possession at all. If they are in possession pursuant, that's the most important vital document to decide. Deed of surrender of possession of the document is what is very important. They do not make a mention of anything of that, except by, they do not even say anything about it. CIT says it has no relevance. Now the tribunal says, whether I receive money or not, I have to pay tax at that year. Now the question, my lord, your lordship are more well versed in the civil law than probably what I have little knowledge on the civil procedure code. If suppose that issue is not honored, there are decisions which goes to say that the suit can be revived. So one such decision I placed in my paper compilation, which I'll take your lordship through. According to me, my lord, the completion of the transaction of transfer happened only in the year 2009-10, and consequently the assessments are to be assessed for 9-10 and not 8-9. Now, my lord, at page 36, para, with the tribunal says it is by clause 5.
One thing,
Not by
sorry,
which-
Mr. Shankar. One thing we wanted to bring to your notice,
Lordship,
this case has to be concluded today. In case it is not concluded, we will have to release it, because this bench is available only till today.
my lord, your lordship, I have done so much, your lordship may treat as martyred, my lord, otherwise.
No,
I try-
you can't. So please finish, I mean, whatever you are.
My lord, because there are about 3 or 5 case laws, and I'm sure my friend also will take a few time. Can kindly ask my other colleague also, my lord, what time he will take. Because he also has given 7 or 8 decisions.
So
So probably even if
please
I come,
conclude within 5-10 minutes, you do.
I have not taken any
All
case
right.
law on merits, my lord. I have not taken a statutory provision. At least 30 minutes I may require, my lord. I'll complete within 30 minutes, my lord.
But then we have to release it and we see. Well, this bench can't, I mean, here.
Your lordship may hear it, continue it on Friday, my lord. I am sure.
No, not Friday. See, he is sitting with in the
I know, my lord. I'm aware. I was not aware that.
Regulatory Chief Justice, we cannot disturb the bench. What to do? We didn't realize, we thought it's a small issue of 148.
No, my lord, it has a
We
very,
do not-
no, 148 part is small. I do not know what my friend has to say. But if my
Ah.
friend is arguing on 148 alone, if he can complete it and if he's,
No, not alone. How can you? It's your opinion.
no, my appeal, I know, my lord. My respectful submission, my lord, is that your lordship may continue hearing it and treat us partnered and hear it on one of the Fridays,
No.
if at all. I do not know how much time my friend
No.
wants to take, my lord.
We still have an hour's time at our disposal. We are ready to provide you.
I know, my lord. I know your
Otherwise,
lordship are
it
ever
will
ready.
be an exercise in futility.
In my deepest of my dreams also, I will not feel that your lordship are not ready. I didn't realize it. Otherwise, I would have told in the morning itself that this matter is likely to take time, because it has a very far-reaching implication on the interpretation of 247(2) and 240. I have not even started the legal argument. And my friend has placed 3 conditions.
Oh. All right, day
Legal
after
argument.
tomorrow. Day after tomorrow. What to do?
Huh?
You begin from where from you have left. Whatever, I mean, you will have to argue. It will come up in other combination. Day after tomorrow. Mr.
Lordship. But may your lordship seek indulgence of treating it as partnered and putting it on Friday, my lord?
ಟೀ ಕುಡಿದ್ರ ಅಂತ ಕೇಳಿದ್ರು ಬೆಳಿಗ್ಗೆ ಕುಡಿದ್ರ ಮಧ್ಯಾಹ್ನ ಕುಡಿದ್ರ ಸಾಯಂಕಾಲ ಕುಡಿದ್ರ ಬನ್ನಿ
So Friday, Mr. Shankar.
Lordship, Friday, my lord.
Friday.
Friday afternoon or whatever time, my lord. Friday, my lord.
Friday it will come up. It will not be treated as partner. Mr. Shankar, the senior.
Lord, I'm sorry to make this submission, Lord. Friday, some
Yes.
inconvenience, Lord. Because one of my relative passed away last week, Lord. There is some ceremony. It is.
Monday.
I'm extremely sorry, Lord.
Mr. Shankar, 7th February.
Yes, my lord.
Mr. A. Shankar Lalit, Senior Counsel with Mr. V. Chandrasekhar, Counsel for the assessee, Mr. K.V. Arvind Lalit, Counsel for the revenue, list on 7th of February 2020. Sir, 41, Sri M. Lava, Sri K.V. Arvind.
All these matters are likely to take a lot of time, my lord.
Oh,
Yes.
so,
What all are pending are all matters. It is a one day matter, my lord. I do not know about others as far as our matters are concerned, my lord.
At least half a day, my lords.
huh?
2 to 3 hours. At least 2 to 3 hours. The contentious issues are there in most of the matters.
What to do? When? Tell us the date, sir, or whatever next
Lords
week.
may fix any date, any Monday, Tuesday, my lords. We have no absolutely. Starting from next week, we can start completing.
May I also make one submission, my lord?
Huh?
Your lordship may consider posting tax matters on Monday and Tuesday, like what your lordship are doing on the earlier.
No, we have only tax matters, Mr. Shankar, nothing else.
Oh, I didn't know that, my lord. I thought your lordship has a
Yeah,
large.
all days in the week. We only have tax matters, nothing substantial. So,
Starting from next Monday, 7th onwards, we will make sure.
we have fixed already one case, right?
Yes, my lord.
42 to 46, right? 41 to 46 matters. Huh? List on 8th of February.
Yes, my lords. Oblige, my lords.
Number 47, Sri Purushottam R.
Appearing for Purushottam R, my lords, since there are too many people in our office who've been infected with COVID, we are unable to make any submissions. A short
You are not
accommodation,
suffering
10
from
days.
COVID, right? Madam, you are not suffering from COVID.
I have just recovered and have started office from today. I was
Today?
infected with COVID, and seniors also. So, my lord, a short accommodation, 10 days time, we will make this.
Praise for adjournment on the ground that the arguing council is unwell. List after 10 days. Number 48, Sri K.V. Arvind, Srimati Tanmay Rajkumar. Yes, Mr. Arvind.
But this matter, you lost my kindly have it after 2 weeks, my lord. Maybe it would be convenient, my lord, physical hearing when available. We'll take a chance after 2 weeks.
Council for the revenue praise for adjournment list after 2 weeks.
Much obliged.
Number 49, Sri K.V.
4950 also after 2 weeks, my lord.
4950, Mr. K.V. Arvind, Mr. A. Shankar Lalit, Senior Counsel with Mr. V. Counsel. Just after 2 weeks. 51, C.H. Parthasarathi, Sri K.V. Arvind.
Your Lordship, this matter, assessee gone under the VSV scheme, Your Lordship. Form 3 yet to receive, Your Lordship. Kindly 2 weeks time may kindly be given, Your Lordship.
For the petitioner praise for an adjournment. On the ground that assessee has availed of the benefit of Vivad se Vishwas scheme. However, form number 3 has not been received. She therefore prays for adjournment just after 2 weeks.
Much obliged, Lordship.
52, CM Lava.
52 is actually covered by decision of this court lordship, but Niralki is on the other side. So I don't know when he
It's
will-
not well met, my lord.
Next week.
Next week.
Next week.
Covered matter, my lord.
Sridhar, you know it's covered.
Yes, my lords. In fact, the covered matter also, Jeevan Niralki only argued on the other side. So same issues involved, my lords.
So
I will serve. Yes, my lords. We have already informed him.
My lord, Jeevan Niralki is aware about this case, my lord. He is.
You are not aware.
No, my lord, I am not aware about the details of this case, my lord.
Chandrasekhar, counsel for the SSC. Mr. Sridhar, for the revenue, the counsel for the revenue submits that arguing counsel is unwell. Next week. Next 53, Sri M. Lava. Vishwanath, Sri K.V. Arvind. Cases don't fall. It can come up tomorrow, right? There is no point in adjournment.
We can just repeat. For the IPO.
Then the remaining cases.
Let me also get. ಆಮೇಲೆ ಇದ್ರದ್ದು ಪೇಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಫೆಬ್ರವರಿದು ಆಮೇಲೆ ನೋಡಿ ಒಬ್ಬ ಅಲ್ಲಿ ನಮ್ಮ ಅಲ್ಲಿ
54, 56, 57,
54, 50, 57,
64.
64. Madam, book 54, 56, 57, 64. In all the cases, write an order sheet. It is stated at the bar that Mr. Stephen J. Niragi is unwell. Let the appeal be listed in the next week.
Obligement.
56, then 57 is petition, and again 64 is petition, not appeal. Remaining cases tomorrow.
My lords.
You said judge. Who's there? Why does not be? Yes, Mr. Sridhar, what do you want?
60, 61, 62. Lordship, after 2 weeks, my lord, I want to file paper compilation like this, my lord, on case loss. 60, 61, 62.
Mr. A. Shankar, senior counsel, K.V. Arvind, learned counsel for the revenue, 60, 61, and 62. Learned senior counsel for the SSC praise for adjournment. This after 2 weeks.
Obliged, lordships.
Humble submission, my lord.
Yes.
List number 2, my lord. Serial number 23. May kindly be have it after 3 weeks, my lords.
It is adjourned as it is. Nothing is being done. It's not being taken up.